If you're a naturalized U.S. citizen, what I'm about to tell you could save you from losing everything. In 2026, immigration enforcement has intensified. Files are being re-examined. Background histories are being digitally cross-checked. Old applications that once sat untouched are now searchable in seconds. Social media is flooded with warnings about mass citizenship cancellations. The anxiety is real, but here's the problem. Fear spreads faster than facts. Can your citizenship actually be taken away? What has actually changed? Who is truly at risk? In the next few minutes, I'm going to separate political messaging from constitutional reality. I'm going to show you what denaturalization actually is, who is being scrutinized, what your constitutional rights are, and what you should be doing right now to protect yourself. If you're a naturalized citizen, you cannot afford to miss this. I'm Edward, and this is U.S. Green Card Signal. If you're a naturalized U.S. citizen, there's one question that's probably crossed your mind this year, and it's not a small one. Can your citizenship actually be taken away? In 2026, immigration enforcement has intensified in ways that feel louder, faster, and more aggressive than anything we've seen in years. Files are being re-examined. Background histories are being digitally cross-checked. Old applications that once sat untouched in archives are now searchable in seconds. Social media is flooded with warnings. Group chats are circulating rumors about mass citizenship cancellations. Headlines are dramatic. The anxiety is real. But here's the problem. Fear spreads faster than facts. So before panic fills in the blanks, we need to slow this down and answer the question the right way. What has actually changed? What is legally possible? And who, if anyone, is truly at risk? Because there's a massive difference between political messaging and constitutional reality. And understanding that difference could mean the difference between unnecessary fear and informed confidence. Hi, I'm Edward, and on U.S. Green Card Signal, I break down complex immigration policy changes into clear, practical explanations so you can understand exactly what applies to you and what doesn't. Today, we're going to unpack what's really happening under the 2026 immigration enforcement landscape, especially when it comes to naturalized citizens. I'm going to walk you through what denaturalization actually is, why older citizenship files are being reviewed, who is being scrutinized, what your constitutional rights are, and most importantly, what you should be doing right now to protect yourself. This isn't about politics, it's about legal structure, process, and facts. Because when enforcement intensity increases, clarity becomes power. And by the end of this breakdown, you'll know exactly where you stand and where the rumors go too far. To understand what's happening in 2026, we have to separate something very important: the law itself versus how aggressively it's being enforced. Since returning to office in January 2025, President Trump has made immigration enforcement a central priority. Executive directives have emphasized stricter compliance reviews, expanded fraud detection, and deeper audits of past immigration records. By early 2026, federal agencies began allocating more personnel and digital resources toward reviewing naturalization histories, particularly cases where there were potential inconsistencies, criminal omissions, or suspected misrepresentations. Now, that shift in attention has caused understandable anxiety. But here's the key point. The law governing citizenship has not fundamentally changed. There is no new statute that suddenly makes citizenship easier to cancel. There is no executive order that allows agencies to revoke citizenship with the click of a button. U.S. citizenship is protected under the Constitution. It cannot be taken away casually, administratively, or through a simple internal agency decision. And this is where nuance becomes critical. There is, however, a long-standing legal process called denaturalization. This isn't new. It has existed for decades under federal immigration law. Denaturalization allows the government to seek revocation of citizenship, but only under very specific circumstances, And most importantly, it requires a formal lawsuit filed in federal court. That means evidence must be presented before a judge. The government carries the burden of proof. The standard is high, clear, and convincing evidence, and the individual has the full right to defend themselves with legal counsel. There is no secret administrative shortcut, no surprise cancellation letter that instantly erases citizenship. Without a federal court case, there is no denaturalization. That structure hasn't changed in 2026. What has changed is the intensity of review and the technology being used to conduct it. And this is where the real shift is happening. Federal agencies are now using advanced digital cross-check systems that didn't exist in this form a decade ago. Older naturalization applications, some filed 15, 20, even 30 years ago, are being digitally compared against criminal databases, travel records, asylum filings, visa histories. Paper archives have been scanned and integrated into searchable systems. Information that once required manual digging can now be flagged in seconds. If a name variation appears across documents, it can trigger a review. If a criminal charge existed before naturalization but doesn't appear in the application record, that discrepancy can be detected more easily. That technological evolution is one of the biggest reasons older cases are resurfacing in 2026. But here's the distinction that matters. Flagged does not mean revoked. A digital alert is not a court judgment. It is simply a starting point for further review. For most naturalized citizens who were honest, met all eligibility requirements, and had no disqualifying issues, increased enforcement intensity does not automatically create danger. Technology may be stronger, reviews may be more thorough, but constitutional protections remain intact. If this clarification already makes things feel more grounded, stay connected here because the goal of U.S. Green Card Signal is simple. Facts over fear, structure over speculation. And now that we've clarified what has actually changed, the next question becomes even more important. Who is truly being scrutinized right now? Because the answer is far more specific than many online rumors suggest. So, who is actually at risk of denaturalization review in 2026? Not all naturalized citizens, not entire nationalities, not people who simply immigrated during a certain decade. What federal enforcement is concentrating on right now is far more technical and far more specific. The focus is on whether citizenship was lawfully obtained at the time it was granted. Denaturalization does not center on what you did after becoming a citizen. It centers on whether there was fraud, concealment, or material misrepresentation during the immigration or naturalization process itself. One major category receiving renewed scrutiny involves individuals who allegedly failed to disclose serious criminal history that existed before they naturalized, especially offenses that would have affected eligibility. The key word here is serious and pre-naturalization. Minor traffic citations are not the target. Forgotten parking tickets are not the issue. What investigators look for are undisclosed arrests, convictions, or criminal conduct that legally would have blocked approval if disclosed. Another category involves identity inconsistencies, situations where different names, dates of birth, or biographical details appear across visa filings, asylum applications, green card petitions, or foreign records. Marriage-based green card cases are also under review in certain instances. If permanent residency was originally obtained through a fraudulent marriage, and that residency later led to citizenship, the entire chain can be examined. There is also examination of cases involving undisclosed affiliations with organizations that could have made someone inadmissible during the original process. Now, here's where fear often replaces facts. Not every mistake qualifies as fraud. The law requires that any misrepresentation be material. That word carries enormous weight. Material means significant enough that if the truth had been known, citizenship would not have been granted. A typo on a form is not material. A short forgotten trip abroad is not material. The government must show that the alleged concealment actually mattered to the outcome, and that is a high bar. But what happens if you're contacted? This is where understanding your rights becomes critical. If a federal agency believes there was fraud in your naturalization process, it cannot simply cancel your citizenship administratively. It must file a civil lawsuit in federal court. That is step one. Without a federal court case, there is no denaturalization. Once a case is filed, you have the right to respond. You have the right to hire an attorney. You have the right to review the evidence being presented against you. And the burden is entirely on the government. You do not have to prove you deserve citizenship. The government must prove you were never legally entitled to it in the first place. Denaturalization proceedings are civil, not criminal. That means the standard is clear and convincing evidence, lower than beyond a reasonable doubt, but still demanding. If you are contacted informally, whether through a letter requesting additional information or even an unexpected visit, you are not required to answer detailed questions without legal counsel present. You can calmly state that you wish to consult an attorney before responding. That is not an admission of guilt. It is exercising your constitutional protection. Let's address the rumors directly because misinformation spreads fastest when emotions are high. One of the biggest claims circulating in 2026 is that naturalized citizens are being mass deported. That is not accurate. Even with increased enforcement and expanded investigations, denaturalization cases represent a very small fraction of the millions of naturalized citizens living in the United States. Another rumor suggests that speaking your native language, traveling back to your country of origin, or maintaining dual citizenship somehow puts you at risk. That is false. The United States does not require cultural abandonment as a condition of citizenship. You can speak your language at home, you can visit family abroad, you can maintain ties to your heritage. There's also confusion around criminal conduct. Here's the legal distinction that matters. Once you are a naturalized citizen, crimes committed after naturalization generally do not make you deportable. Deportation is a consequence applied to non-citizens. A citizen cannot be deported unless citizenship is first revoked through the court process. Criminal conduct only becomes relevant to denaturalization if it existed before naturalization and was concealed in a way that would have affected eligibility. Another claim circulating online is that certain countries are being unofficially targeted for citizenship review. There is no public statute or formal directive that strips citizenship based solely on national origin. So where does this leave you right now? Not in panic, but in preparation. If you are a naturalized citizen who disclosed your history honestly, met all eligibility requirements, and completed your process lawfully, your citizenship remains one of the strongest legal protections. The first practical step is organization. Keep copies of your naturalization certificate, your green card records, and your original applications. Maintain both digital backups and physical copies stored securely. Second, if your immigration history included complex elements, consider scheduling a confidential review with an experienced immigration attorney. Not because you are automatically in danger, but because clarity eliminates uncertainty. Third, respond promptly to any official correspondence. If you ever receive communication referencing your naturalization, do not ignore it. Do not assume it is a mistake. And for green card holders watching this, the situation is slightly different. Permanent residents do not have the same constitutional shield that naturalized citizens possess. That makes compliance essential. File taxes consistently. Avoid criminal conduct. Maintain continuous residence and apply for citizenship as soon as you are eligible. Immigration policy in the United States has always moved in cycles. enforcement expands, courts review, political winds shift, legal challenges narrow or reshape executive actions. Technology has evolved. Data systems are integrated. Historical inconsistencies are easier to detect. That is real. But constitutional safeguards remain real too. If this breakdown has helped you replace rumors with structure and fear with facts, share it with someone who needs clarity right now. Stay informed from reliable sources and make sure you're subscribed to U.S. Green Card Signal so you don't miss future updates as policies continue to evolve throughout 2026. Millions of naturalized citizens continue to live, work, vote, build businesses, raise families, and contribute across every sector of American society. Enforcement priorities may shift, but lawful citizenship remains one of the strongest legal statuses in this country. Stay informed, stay prepared. I'm Edward from US Green Card Signal, and I'll see you in the next video.